Well, we got Ken again this week. This is part two of his four-part series, and I know Ken's busy. He's got all kinds of deals going on. So I think with no further ado, we'll kind of let Ken jump on and talk about adding a name to the contract. I think that was the deal, right, Ken? It was
That's right.
adding a name and a kind of an assignment and a couple others there. So why don't you go ahead and do your thing, and we'll if anybody has any questions, whether it's regard to adding a name or anything else that you have for Ken, please feel free to put it up there, put it in the chat or whatever. Wait till Ken is asked for questions, and we'll bring it in there. I'll leave it to you, Ken.
Okay, thanks, Doug. Hi, everyone. I hope everyone's having a good day. We're going to keep this again short. These little sessions, we're going to keep them to 15 minutes or less. So I'm just going to quickly recap from last week. Two takeaways from last week. Number one, don't change the dates on contracts at the last minute, because there's 6 or 7 different players in the contract that need to be on board to do that. Chances are, in our experience, anytime somebody changes a date at the last minute, it causes a lot of problems. Sometimes it causes the contract to collapse. So just because your client got some cheap tickets for an airfare at the last minute, I would advise them it's not a good idea generally to change the contract dates unless you have at least 2 weeks notice. Second thing, don't close a sale and a purchase on the same day. There's plenty of things that can go wrong on that. Have we done it before? Yes, we have. In today's world, though, everything moves a lot slower than what it did before. So if you can't close and you've sold your property, but you can't get the money fast enough to buy the other one, you can lose your purchase, lose your deposit, and you can be sued as the realtor for not explaining the considerable amount of risks on a same day closing. So that's the takeaway from last week. For this week, something we've seen a lot in contracts over the years, for one reason or another, somebody wants the ability to add another person to the contract after it's already signed. So obviously the thing would be to have everyone sign the contract as a purchaser, but for some reason or other, we've seen these clauses that said, well, the buyer reserves the right to add the mother, the dad, the brother, the sister, the kids to the title or to the contract prior to the completion date. So we see that quite a bit. And for one reason or another, it's usually perhaps to help the person qualify under the mortgage, or maybe that the person doesn't have enough wherewithal himself financially. But notwithstanding that, that is a clause we see a lot. And so, okay, so let's say that you have everyone sign the contract, you remove the subject conditions, and now the broker comes along and says, guess what, you need mom and dad on the contract. So now we have to add mom and dad to the contract. So the fact that you've put something in the contract to say we can do it, that just step one. That's not the whole thing. That's not the end of the matter. That just says you can do it. Oh, how do you do it? How do you add someone to a contract that didn't sign it in the first place? Well, in contract law, there's this thing called privity of contract. So that means that only the parties to a contract can enforce the contract. So a buyer and a seller, they're the parties to the contract. They're the only ones who can change it. They're the only ones who have rights to that contract. So now between the two of them, in your offer, they've said that the buyer has the right to add someone else to the contract. So, okay, so what does he do to do that? As you know, clause 20A of your contracts does not permit assignments. Okay, so you can't assign a contract to someone else unless the seller agrees. And so there's 2 ways to add a person to a contract. One is by assigning all or a portion of the purchaser's rights to a third party, like the mom or dad. And the other one is to do an addendum and have people sign it. So the first one is usually one that will be done by the lawyer or the notary, because I doubt whether you guys have a standard form of assignment in your real estate board precedents. So that being the case, that's usually going to be shuffled off to the lawyer. And I think if you've got that clause in your contract that says the one party reserves the right to do that, I think that satisfies clause 20A. And I don't think the seller could be in a position to say, well, you can't do that. You can't assign the contract because you've already put that clause in your contract. So in that case, the lawyer or the notary, if you want to do it that way, you don't want to have the seller sign anything. Basically, the lawyer would drop an assignment saying that party A assigns the contract to party B, and or both. You can assign all of it or a part of it. And then you serve that assignment on the other side, and that's it. You close with the new party. So now you have the buyer and the mom and dad, and they're all going to be buyers, and there's nothing the seller can do about it. Now, again, having said that, if you're going to do something like that and someone's not buying clear title, so most people do take a mortgage out, make sure you talk to the banker or the mortgage broker about adding the parents or whoever this third party is, because banks do up these mortgage applications on the basis of who's made the application. So you come along at the last minute and say, oh, by the way, mom and dad are going on the title. It's a fact that if someone is going on the title, they have to go on the mortgage. Okay, does anybody know why? So you can't have a person A and B are on the title, but C is now on the title, but they didn't sign the mortgage. They weren't part of the mortgage application. Does anyone know why the bank is not happy with that?
Well, they might have other obligations that might affect the title.
Exactly, but also the bank wants to be able to foreclose on the whole title. So if I'm on the title, but I didn't sign the mortgage, they can't foreclose on my portion. Okay, so maybe they have 2/3. So no bank will mortgage 2/3 of the title. They have to be able to foreclose on the whole thing, which means everybody who's on the title is signing the mortgage, no exceptions. So if you're going to add somebody at the last minute or even a little bit before that, make sure the bank's on board and make sure the bank's got enough time to redo a mortgage application and approve the mom and the dad, because that can throw a wrench into things right at the last minute. So again, this idea of, first of all, don't do anything at the last minute. That's going to cause nothing but problems. But let's say you have a few weeks to go and your broker or your banker said, yeah, you're going to have a tough time for some reason. We need somebody else to quote unquote co-sign. Now they could sign as a guarantor. If you're signing a mortgage as a guarantor, you don't have to be on the title. But if you're signing as a borrower, as a mortgagor, you have to be on the title. Okay, so a guarantor has different rights than a co-signer. So that's one way to do it. So in that case, as I say, normally the lawyer or the notary would do the assignment, have the assigner sign it, have the assignee sign it, and serve it on the other side. Now, from your point of view, you say, well, we don't want to do that way because it's going to cause our client to pay some extra money to have someone drop this assignment. Let's just do it by an addendum. Okay, so what does the addendum say? The addendum would say the buyer and the seller agree to add a third party, call them the additional buyer, to the contract. Okay, well, that's a good start. But what else do you have to do other than that? Like, you have to add something else to that addendum. Does any idea? Anyone have a thought of who else might want to you might want to have to sign that addendum? Okay, so you have the seller signs it, you have the buyer signs it, and you have the new buyer sign it. Okay, so you want to have this new person, the mom and dad who are being added, they've got to sign the addendum. Why? Just what we said earlier, privity of contract. They want to become a part of the contract, and so does the other buyer, and so does the seller for that matter. Because once the buyer signs the addendum and the new buyer signs the addendum and the seller signs the addendum, you have a amended contract and everybody is bound under that contract. So if it goes sideways, the buyer's getting sued, the new buyer's getting sued, or the other way around, those two parties can sue the seller, okay, if the seller defaults. So I mean, I've seen lots of cases where the two parties sign it, but you have to have the new buyer sign it. And generally I suggest putting in another clause saying, you know, the seller and the buyer agree to add so-and-so to the contract. And then so-and-so, there's a paragraph that says so-and-so, the mom and the dad have read the contract and they agree to be bound as purchasers under the contract. And then they all sign the addendum. Then you're good to go. So I'll send some simple wording over to Mike and Doug, and just so it's 2 paragraphs, here's what we can throw in, have everybody sign it, and you're good to go for adding a party to a contract. It's binding on everyone. Everyone has rights to that contract, and there's nobody backing out. If you don't do that, and the new buyer never signs anything, then he's not bound to do anything. He's not bound to sign any of the paperwork, the mortgage. He doesn't have to close, and nobody can sue him. So as you guys all know, and you do everything in writing as realtors, okay? You don't just say, well, let's change the date. Yeah, me and the other realtor agreed to it. On the phone, we're good to go. No, you follow that up with a written addendum, which everybody signs, okay? Because everything should be in writing as far as a real estate contract goes. So this is no different, except the new buyer is going to sign it as well. So just keep that in mind if that's the way you want to go. The other thing you always want to do with a contract when you're making amendments to it by way of an addendum is to add a clause saying that all other terms and conditions remain in full force and effect and time remains of the essence, particularly when you're changing dates. If you change a date and you just say A and B agree that the closing date goes from June 1 to June 6, then the possession date goes from June 1 to June 7, and that's all. You leave it at that. Basically, there's some case law, rightly or wrongly, it's out there, that says you have taken the time of the essence clause out of the contract. Its time is no longer of the essence. What does that mean? Time of the essence means what the time in the contract specified is the time the court is going to enforce. So for example, if you read your standard real estate contract, there's a clause in there that says the completion shall occur by 4 o'clock on the completion date. So that means the buyer's lawyer has to have filed the transfer at land titles by 4 o'clock. That means 4 o'clock. It doesn't mean 4:30. It doesn't mean 5:30. It doesn't mean 7:30. It means 4 o'clock. So there's been some case law where somebody purports to close at 5 and the seller goes, no, you can't close at 5. You're past the 4 o'clock deadline. It's the deal's over. The contract's finished. So what time of the essence means is, yes, we're closing today and we're closing by 4 o'clock today. And that's the way it is. Now, of course, you can always change that with the other side's consent. But if you don't have that consent, time of the essence means just that. Once you extend a contract and you don't put that clause in there saying time remains of the essence, it's gone. Okay, that means I can close today. I could probably even close tomorrow. I close at 10 o'clock tonight. Maybe we can close tomorrow morning, maybe even tomorrow afternoon. There's nothing you can do about it. So it becomes very difficult once you take the time of the essence clause out of a contract, because it means we'll close within a reasonable period of time. What does that mean? Well, today, tomorrow, maybe the next day. What's reasonable would be decided after the fact by a court. So all real estate contracts run on a clock. Closing date today means today. In fact, if you read the contract, it means 4 o'clock today. Once you take that away, it's a big problem. So just remember, if you're ever extending a deal, always put that extra clause in there saying time remains of the essence, and then you don't have a problem. If you want time to not be of the essence because you think maybe you can't close on time, just leave it out. Just go ahead and say we extend the date to a certain day. And then if you can't close on that day, you've got a pretty good argument saying, yeah, I'll close the next day. I'll close the following day, and there's nothing the seller can do about it. So again, you can use these clauses for your benefit or not, but most of the time you want time to remain of the essence. You want the person to be stuck closing on that date, because if he doesn't, then there's legal consequences to that your client might want to take advantage of. Anybody got any questions? Yes. Go ahead.
Still on the pre-sale assignments, that if the assignee, the last person that purchases, that the assignee, if they don't complete, everything falls back onto the lap of the original purchasers. That's still the case?
It is. So if you guys are, any of you are involved with pre-sales are, basically you're buying something from Boza or Polygon, which is going to close in a year, 2 years, 3 years. And those contracts are the ones that tend to get flipped. And just a little bit of history for you guys on clause 20A of your contracts. Why is there a clause 20A in your standard real estate contract? It makes absolutely no sense. Because in 2016, when Christy Clark was trying to get reelected and there was this big flap about people flipping contracts, she put a bunch of pressure on the real estate board to put a new clause in the standard agreement, which is clause 20A. 20A says you can't assign the contract unless the seller agrees. In the history of how long we've been practicing, which is over 25 years, we've seen two clients flipped a purchase contract in 25 years, just between party A and party B. On the other hand, 99.999% of flips happen with pre-sales. So what does Christy Clark do? We change the contract that nobody flips and we leave the other one alone. So it's still you're still fully able to flip pre-sale contracts. But as Michael said, when you flip a pre-sale contract, the original buyer still remains on the hook. That's very clear. The developers always do that in their form of contracts. Everything falls apart, the original buyer is forced to buy. Okay. Now he's going to sue the assignee because he's going to say, well, we resold the contract to you, you breached it. And part of the assignment agreement will say that the assignee, which is the new buyer, will indemnify the old buyer if there's been any problems. Now, having said that, if the new buyer can't close, that means he has some financial problems. So how much it's going to help the original buyer, who knows? But so the thing about when you're talking about an assignment, the simple assignments we are talking about to assign a contract between party A and party B, just a buyer and a seller, they're way different than the pre-sale assignments. Okay, pre-sale assignments, in every case, there's going to be two pre-sale assignments, never one, always two. Why two? There's one that the board does. The board has got a fairly long, complicated document that deals with every single issue you can think of. And it is never, ever, ever signed by the developer. Even though there's a nice clause at the end of it says the developer signs here, no developer will ever sign that. So your assignor and your signee go ahead and you negotiate this pretty complicated contract. It's probably always a good idea to have a lawyer take a look at it before it's finalized. And then you have to go to the developer and say, well, okay, we're going to pay you 1%, 2%, 3% as an assignment fee. And the developer goes, okay, hand over the dough. And by the way, here's my form of assignment that you have to sign when you're giving me the money. Oh, okay. Well, what is that one about? Well, that's the one the developer cares about that leaves the original buyer on the hook and he gets his money. So flipping $1 million property with a 3% assignment fee, that's 30 grand. So that's not a small fee. So developers have seen over the years that this is a lucrative thing to allow people to buy and flip and reflip and reflip. Some contracts have been flipped 2 or 3 times. If you guys are familiar with the Shangri-La downtown in Vancouver, some of the contracts, we've had clients that this is the 3rd or the 4th flip before that thing was built. So the point is the developers are making money on every flip. And it's no longer just 1%. A lot of them are 2%, and now I've seen a few that are 3%. And some of them even make it 3% of the assignment price. So the assignment price is the original purchase price plus a lift. So in today's world, properties are going up. So generally, for me to take over your contract from you to get an assignment, I've got to pay you some extra money. You guys call it a lift. That's the way it's referred to in your standard board assignment document. So sometimes the developer's saying, well, no, I want the 3% on the whole thing. So not only on the purchase price, but on the lift as well. So there's no downside whatsoever for a developer to allow someone to flip a contract because they're making an extra 2 or 3%. Now, having said that, every single pre-sale contract says the same thing. It's completely at the developer's discretion whether they let you flip it or not. Okay. So they can say no, just for no reason. We don't need a reason, just no. Now, practically speaking, what is the reason? They want to sell out all of the project first, and then you can flip it. Because if you're flipping your title, you're competing with the developer. Saying, well, the developer still got some units for sale and I'm going to resell mine. So generally, quite often the developers say no. There's a period of time you can flip it and we'll let you know when it is. And then generally 1 or 2 months before what they call the final completion date, when people actually close, they will say no more assignments. Okay, because it's just too much hassle for us to do these, again, last minute changes. So quite often they'll say no. So again, if you guys are doing assignments, if you're like Rennie and Associates, they got a whole frigging website of all these assignments because they do a lot of pre-sales for the big developers. If you're going to get involved in those, Certainly, by all means, give us a call. They're pretty complicated contracts, these, even the standard board contract. But as I say, keep in mind, there's always going to be two. There's that one, and then there's the developer's one. And even though I've looked at both types of contracts, there's nothing wrong with yours. The one developers could certainly sign them, but they won't. They just say, fine, we have a big law firm drafted our own form assignments. You're going to sign that one, or you're not going to sign the contract. But so again, the thing about these pre-sales, as you probably know, if any of you have been dealt with them, one of the biggest risks of a pre-sale is a moving completion date. You never know when it's going to be. So if you're buying toward the end, when it's only a few months away, then that's a lot safer than if you're buying, you're flipping a pre-sale contract with 3 years left to the closing date, because there's a lot of things can happen. If you're ever going to buy a pre-sale, you're going to advise your client to buy a pre-sale. Just, you can have a look at our website. We got 7 risks of buying a pre-sale. They're real risks. They get smaller and smaller and smaller as you get toward the purchase date. Having said that, one of the risks you still can't mitigate, even by buying toward the final phases, is the finished product, because you never see the finished product until 2 weeks before the closing date. And if you don't like it, it's too bad for you, because there's nothing you can do about it. So, not saying pre-sales, never buy a pre-sale, but just look at all the risks, explain them to your client, and then basically say, okay, if you can live with these, great, let's go look at some pre-sales. The other thing for you guys, this is just something that's floored me for years. The vast majority of people who buy a pre-sale don't have their own realtor. This is completely crazy. They should be hiring you guys to give them advice about buying a pre-sale, if that's what they want to do. Because the person on site, that's half the time they're not even a realtor. If they are a realtor, they work for the developer. They are not going to give good advice to your buyer. So if you guys are doing your marketing material, sending out stuff to your clients once in a while, for Pete's sakes, remind them, if you're ever going to buy a pre-sale, or your son or your daughter or your brother or your sister, have them call me first. Okay, I will help them. If that's the way they want to go with a pre-sale, they should be engaging you to represent them, not using the realtor on site, not using the salesperson on site, because they have no interest whatsoever in protecting the buyer's position. So that's something, just throw it in your marketing materials, because I've had plenty of cases where people say, well, I didn't think I needed a realtor. I mean, there's a developer there. What do I need my own realtor for? You need your own realtor way more on a pre-sale contract than you do on a regular contract, because pre-sale contracts are 99% in favor of the developer and 1% in favor of the buyer. Your standard contract that you guys use all the time is pretty fair. It's probably 55-45 in favor of the seller. That's relatively fair overall. The other ones are 99-1. So that's why you really need a realtor when you're buying a pre-sale, and not the realtor working for the developer. And the same thing goes for the law firms. The developers sometimes say, oh, we got a preferred law firm here, they'll help you out. Never use that firm. Why? Because they're beholden to the developer. They're not going to represent the clients, an individual buyer. If something goes wrong, they're going to go, well, you know what? Maybe go hire another lawyer, because I'm getting all this work from Polygon or Bozar, whoever. I'm not going to jeopardize that over one client. So whether the lawyer you're going to use, or whether it's the realtor you're going to use, it should always be your own lawyer or your own realtor on a pre-sale. Questions, guys? Yeah.
Just as, I guess, words of wisdom for you guys. Take a look at what the assignment contract says. This is from our past experience. Sometimes these project companies are the only companies that are allowed to assign the unit. So you've done all the work. You found Bob Smith. Bob Smith buys a pre-sale from ABC Project Marketing, representing whatever developer. But then you've just allowed that project marketing company to take your customer, and if they want to assign that property or sell that property, you're giving away your customer. And there's a reason for their clauses. Those companies want to take your customer. Lots of inventory out there, so choose your battles of product and stuff, but be conscious that there's a risk that some of these companies will try to take your customer away, and that's just common sense for you guys to look at.
Great, thanks. Ken, I just posted on the comments there on the chat there, the clause that the real estate council would like us to use for adding a name to a contract when you're writing the initial contract. And I think what you were talking about is doing it after the fact on an addendum. If we put this clause within the contract itself when it's initially signed, we would also provide the seller with a disclosure of assignment. That's the requirements by law from the BCFSA. But that's the clause there, notwithstanding 20A of this contract, the buyer may, without the further consent of the seller, add, and they want us to put the specific names in there, an additional buyer prior to the completion, and the seller agrees to sign the completion documents as are necessary to reflect the addition. The seller's consent does not release the buyer from any liability in this contract. So that's normally what we use to add mom and dad on.
Okay, so that's basically what you're doing, though, is you're that's a form of assignment. Essentially, the seller's saying, yeah, you can go ahead and assign a partial interest to mom and dad. The thing about that, though, let's say mom and dad don't sign, then what?
Well, then they don't have to sign. This is
then your contract can fall apart, because mom and dad are never a part of the contract until they actually get to the lawyer's office and sign something.
Well, no, they're not part of the contract, and they don't have to be. This says that they can assign it if they require. So what that would allow is that if we do need mom and dad because the bank wants it or whatever, they could go to you and they would sign the assignment then and become part of the contract at that point in time without further notice to the seller.
Yeah, well, and no assignment needs a further notice to a seller. They just generally get the assignment, or in this case, they get the new documents with somebody else on the documents. But I guess what I'm saying is, I suppose you can trust mom and dad to do what they say they're going to do. But as far as I'm concerned, when someone says I'm going to be on a contract, but I'm not going to sign anything until the last minute, then I'm not on the contract until the last minute.
No, that's not what this is. The intent of this is for. This would be more for a young couple that are trying to, they've got everything done, they bought the house, but they may need the mom and dad at a future point in time with the, because we're still applying for financing. The banker may say, we don't need mom and dad, don't worry about it. But in the case that they do, we don't want to do an addendum to open up the contract. We want to have carte blanche approval to add them if we want to. That's the purpose of this.
No, I understand it. So basically what you're doing is it's a form of assignment in advance. The seller's consenting to these people to be added to a contract at a later point in time.
If required.
If required, of course. But I guess my point is, real estate, at least the way I see real estate, everybody signs documents. Nobody says, well, at the last minute, I'll just show up and sign something for you. And again, I guess if you want to trust whoever this third party is to sign when they say they're going to sign, then so be it. On the other hand, let's assume that, let's play devil's advocate here for a second. Mom and dad sign the documents, and then everything goes south and there's a lawsuit. So I guess the question would be, what rights do mom and dad have to sue? Because really, they were never added to any contract. They just signed.
Well, you have the right to add them. You could add them. They could sue back. I mean, that the intent here is maybe a little different than your position of the law. We just want to put mom and dad on if we need them. That's all we want to do here. And this clause allows us to add them without going back and opening up the contract. If mom and dad don't sign, they don't want to be on the contract, that's fine. They may not be able to get their financing, whatever. This is all for the buyer, not the seller. You know what I mean?
No, I understand that. Another interesting point you made about opening up the contract. This is something that's I see all the time, which is, if you propose an addendum if you want to change the date, if you want to do anything, you're opening up the contract, and that's going to allow the seller to just walk away. No, it's not. Okay, so you put a proposal in to change the date and the seller says no. That doesn't mean you can say, okay, fine, the contract's null and void. I'm selling it to Bob Smith instead of you. That's not what the law is. Okay, because you're not opening up the contract. You're asking the guy to change the date and he can say yes or no. Now, a lot of realtors will throw in this big, huge paragraph first that says this is not a counter offer, this is not opening up the contract, if this is not accepted, it has no effect, etc. That's fine. You want to throw that in, go ahead. But as far as I'm concerned, here's a case of opening up the contract. I want to change the date from December 1 to December 6. And if you don't agree, I'm not going to close. That's opening up the contract. Okay. So, you know, there's plenty of cases out there, and this includes backup offers as well. What can the original buyer and seller do if you've got a backup offer in place? Quite a bit. Okay, but everybody seems to think, well, no, that's not the case. You make any change whatsoever, you're breaching the backup offer. That's not what the law is. So, you know, I get it. You don't want to mess around with the contract. That's what I started this today's talk about. Well, don't mess up the contract. Once it's signed, leave it alone. Don't change it at the last minute. But just because you're proposing a change doesn't mean you're opening up the contract and letting the seller walk away. That's not how it works. And same thing with the seller. If they want to change the date and your buyer says, no, we're not changing the date, it's not convenient for us, that doesn't mean the buyer can walk away. So this is, you know, if you want to throw the extra, go ahead.
The point of the clause here is to prevent an addendum going out because it's stressful on everybody.
Oh no,
in our field, there's a question of whether or not opens up the contract. There's arguments on both sides, and like you just said, yes you can, no you can't. We don't want to get into that. That's not what we're here for. We're here to write a binding contract. If we need to add mom and dad later down the road, we don't want to do an addendum. It's already in there. We'll send it to you, Ken. We're going to add mom and dad. That clause is in there. We're okay. We can do that without their consent. Go ahead and add mom and dad. If mom and dad don't want to come on, we don't need them. We don't need them. It's not going to change anything. We don't have to go and ask for an addendum to add mom and dad. That's why that clause is there.
I don't have a problem with the clause you just read out, Doug. I think they've added some extra stuff in there, which will do the trick.
Okay, that's really what adding that name is. So we want to do it right up. What I tell the guys is do it up front. If you think you're going to have to add mom and dad and you're not sure, put that clause in your initial contract right away, so that once everything's said and done, and then you have to go apply for financing, and the financing guy says, no, we need mom and dad, then you have to do an addendum to get the authorization of the seller, because it says right in the contract, 20A, we need their consent to add a name. With this clause, we don't need to do that. That's all this is all about. That's what that clause is about.
Yeah,
so you're okay with that. That's what these guys need to know. Put it in early, put it in your initial thing, and then we don't have to ask for permission later.
That's true. Let's say you forget to do that though. You can still do an assignment, which the lawyer can draw up, add mom and dad by way of an assignment. You can still do that if you forget the clause. I agree with Doug, put the clause in the first place. If the circumstances change later on, you didn't put it in, you can do an assignment. The seller does not have to sign the assignment.
Yeah, that's kind of not what we're hearing from the BCFSA, you know what I mean? So no disrespect any way here, but I'm just kind of trying to, what we try and do is prevent these arguments from coming up, or whatever you want to call them, these disagreements from coming up going forward. If we put that in early, we're okay. What the BCFSA says, if we don't put that clause in and we do want to add mom and dad later, we have to do an addendum. And that's where the clauses you said would come into place, and we'd have to do it with the wording you're going to give us. That's kind of an after the fact thing.
Sorry, I think we're just missing each other for a second. I agree totally with what you said, Doug, but let's say you as long as you've got a clause in there saying mom and dad can be added, you've got a better clause, you've got a more extensive clause that the board has drafted up, which I like. But you're right, absolutely right. If you don't have any clause in there at all, you just forgot about it, and then the broker comes along at the last minute and says, guess what? We need to add mom and dad. We don't have the clause you suggested, Doug. Well, now you've got to go back to the seller and ask them, because we can't just do an assignment because of clause 20. Clause 20 is the one that stops you from doing assignments. Normally, every contract is assignable under section 36 or so of the Law and Equity Act or the Property Law Act. But this clause that the government has more or less pushed into the contract, 20A, says, no, you can't. Now we need to get the seller to agree. So by putting the clause in that Doug's talking about, the seller's already agreed. You got his consent. So if you use it, great. If you don't use it, you're covered. So, you know, that's certainly something. Talk to the banker, talk to the broker up front and say, is there a need? Maybe we're going to need somebody else. Then you throw the clause in, and if you use them, great. If you don't use them, it's no problem.
Awesome. Yeah. I agree.
So I hope we haven't
questions?
confused you guys with that. I'm sorry about that back and forth there, but if there's anybody has a question, just throw it out. Guess not.
I think we're good, Ken. We'll roll on. We'll let you go, and we'll pick it up next week. And if they have any questions back then, maybe you'll think of them in the meantime as well. So thank you for coming. We appreciate it.